inherent and plenary jurisdiction of the Supreme Court. That is when you go to review petitions, the Supreme Court has all the power to review its own judgment or any order which it has pronounced. The rules provide, Order 47 provides that a review petition must be filed within 30 days from the delivery of the certified copy of the judgment or order sought to be reviewed. That the review is under Order 47, somewhat like the review provisions of the CPC, that the jurisdiction is limited where there is a glaring omission or a patent mistake or where a grave error has crept into the judgment. And the mere fact that there is some other judgment which says something else is not necessarily a ground for the review. Now, the Supreme Court has created, under its own inherent and plenary jurisdiction, curative petitions. Curative petitions came about primarily when the Supreme Court rules itself provide that after a review has been dismissed, there cannot be a second review. But despite the fact that a matter has gone through the court process, has had a judgment of the court, and the same court has reviewed the judgment and found no error, yet there are situations where something has occurred later which would cast a shadow or a doubt upon the original judgment. So then the Supreme Court created a solution in the Rupa Ashok Hurra case, which was a matrimonial matter, but where the settlement, with regard to the settlement, there were certain doubts. So the court, they said that it would entertain a curative petition if a senior counsel or a senior advocate certified that there were two major grounds existed. One was where, due to some defect of procedure or otherwise, a party was not heard. The second was where the court was disabled due to some cause from hearing that matter. For instance, in the old classic case of the Grand Canal Junction Company, there was a Lord Chancellor who had a share in the company and yet heard the case. That case was set aside by a subsequent judgment. That judgment was set aside by a subsequent judgment. So something like that, where if due to some fault in the court itself, and if it was so certified by a certificate given by a senior counsel, then the Supreme Court would look at the original judgment or take a relook at the original judgment in a curative petition. So if there is one bit of practice and procedure, practical aspect of practice and procedure is that there are senior counsels and senior counsels. Some do certify curative petitions, some do not certify any. And those who do not certify any often point out to the two requirements under Rupa Ashok Hurra. Now, the two straight lines which Rupa Ashok Hurra drew have been muddied a bit recently in the recent judgment in DMRC, where the court has stated that it extends to cases where a court acts beyond its jurisdiction, resulting in a grave miscarriage of justice. So at this stage, if we go back to that early passage that I showed you from Glanville-Williams, it does seem to me that as far as curative petitions are concerned, there can be more than one answer. And unless the court again speaks as to what are the kind of situations that the DMRC case envisages, I suspect that there will be more and more people who will be willing to certify curative petitions. Contempt petitions, of course, go with any court of record, and the Supreme Court obviously has powers of contempt. In addition to powers of contempt, it also has powers which require all authorities to come to the aid of the court, all civil authorities to come to the aid of the court. One of the leading cases has happened recently in Prashant Bhushan's case, that the constitutional power of the Supreme Court is independent and is not limited by the provisions under the Contempt of Courts Act. There are rules to regulate the proceedings for the contempt of the Supreme Court, which establishes the legal framework to govern contempt proceedings.